come to our firm, you've retained us, you're charged with any type of criminal offense. You say to me, Mike, I'm innocent, I intend to plead not guilty. What is a test in Canada really for proof? How does the Crown prove a case against you? Well, first of all, in order to convict you, the Crown has to prove beyond a reasonable doubt that you are guilty. What does that mean? Well, first of all, if you're only probably guilty in the judge or jury's mind, you should be acquitted. Probable guilt is not enough. It doesn't have to be to absolute certainty, though, but certainly reasonable doubt is far closer to absolute certainty than it is to mere probability. So you can see what a powerful test that is. In many cases, you can win a criminal trial just based on that reasonable doubt. And in many cases, you don't even have to testify. It's up to the Crown to prove. That's your choice in conjunction with consulting with your lawyer whether you need to testify in a particular criminal case. Now, what if you do testify? How does the judge determine, or the jury, credibility, your credibility in the Crown's case? Well, it's a three-step test. And the first part of the test is this: you've testified. If the judge or jury will then say to themselves, do I believe the accused evidence? If the answer to that is yes, I believe them, you're going to be acquitted. Now, that's hard to get to that point. Let's face it, politically, it's difficult for judges to say that in open court. I've won many cases where they have, but you don't need to get to that level. You just need to create a reasonable doubt. But again, judges sometimes don't want to anger a complainant by saying they believe the accused over her. So we go on to the second part of the test. Does the evidence of the accused, that is my testimony or evidence that I presented other than my testimony or my other witnesses that I presented, does that create a reasonable doubt? If the answer to that is yes, you win. That's great. You're not necessarily believed. It doesn't matter. A win's a win. Now, the third part of the test is very powerful as well. I've often heard judges say, look, I don't believe the accused, or I don't necessarily believe the accused, but does their evidence leave me with a reasonable doubt? And the answer is yes, it does. So judges will often say that I don't necessarily believe the accused, but I'm left in a reasonable doubt. That's a win. A win's a win's a win on branches 1 to 3. And that's why you can win many criminal trials in Canada, and especially when it's only your word versus the word of another complainant.